Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. This document we're about to go over actually came out in the end of the last live stream, but I had to go and ask my boss if I could clock out late tonight so that I could do this right now. This is not going to be as long as the last one, thank God, but we'll go over this really quickly. I'm not going to waste any time really because I don't want to be working too late tonight. Give me one sec. The thing about my job is it doesn't pay as well as when I was working full time in the hospital, but you can't really beat the flexibility, man. There's a big quality of life improvement. All right. This is another motion to compel against the Wayfarer parties filed by Blake Lively. Remember, the last one was relating to financial documents. The judge partially granted, partially denied that. But this is a completely different situation we're looking at here. So, oh, hey, what's going on? How was the pickup shift in the ER? I was not expecting it, so it was not fantastic, but hey, it's over now, right? So, okay. Dear Judge Lyman, pursuant to Rules 1C and 4C of the court's individual rules and practices, Blake Lively respectfully submits this letter motion to compel Wayfair Studios and It Ends With Us Movie LLC to produce materials responsive to Ms. Lively's fourth set of requests for production, which seek documents and witness recordings concerning Wayfair's purported neutral workplace investigation into Ms. Lively's sexual harassment and retaliation claims. Wayfair is withholding such documents and recordings, claiming, at least for now, attorney-client privilege and work product. So when she says witness recordings, I want to be clear. Like, this does not mean that somebody definitely witnessed harassment or anything like that. It's probably going to be more stuff like that video of where they were shooting the dancing scene that they put out in the press, before the judge kind of cracked down on the litigation in the press a little bit. So it's not necessarily that it's going to voice crack. Whoa. It's not it's not necessarily that it's going to show any harassment, but this stuff is relevant to their investigation into the, alleged harassment. So I just want to be clear about that. She's not necessarily saying, well, she's probably going to frame it that way, but she's not necessarily saying there is evidence of sexual harassment, but there is something, I guess some sort of recordings or something that she's going to use to try to prove harassment. So that's what I'm getting from that. The so-called investigation is a disingenuous charade. What the fuck are you talking about? Wayfair failed, although it was legally required, to investigate Miss Lively's concerns when she first raised them in May 2023. Had it done so, Miss Lively would have participated in such an investigation, and it would have substantiated the sexual harassment she suffered while on the set of the film It Ends With Us, which included, among other things, Mr. Baldoni's unsolicited discussions about his addiction to pornography and sex life, and his improvised intimacy scenes without Miss Lively's consent. If her complaints were promptly investigated, as the law requires, she may also have been spared the retaliatory smear campaign by Wayfair and its co-defendants. Instead, Wayfair waited years until late January 2025 to initiate this investigation. By that time, Wayfair had already forcefully publicly denied Miss Lively's allegations and sued her and several others for $400 million for making the very same allegations that are now the subject of this neutral investigation for a workplace that no longer exists, the film set. What's more, by January, its counsel had repeatedly called Miss Lively a liar in widely circulated media interviews. So, why would they call her a liar? Could it maybe be that she never actually made any formal sexual harassment claims to be investigated? Because that's one thing I think I would bring up. Just saying. Like, they're stating as a fact that she made actual complaints, or like that was something that needed to be investigated. There was no actual complaints made. Sony confirmed as much. So that's ridiculous. She did not go to her union, or do anything else, because if somebody actually investigated the things that she was saying, then it would have, it would not have gone her way. Rather, she chose to, use this in private to pressure people into giving her what she wanted. So, no sympathy for me. Just saying. Again. Oh, what the fuck is this now? Okay. Sorry. There's going to be another extension in the Wallace case, I guess. We'll get to that later. Under the guise of the investigation's neutrality, Wayfair is conducting one-sided interviews of unsuspecting third parties, potentially tainting the ongoing litigation. What the Jesus. Potentially tainting the ongoing litigation while reserving for itself the option of whether it will release its findings or bury them behind a cloak of attorney-client privilege. Hold on. So this investigation, is it over or no? Wayfair is conducting one-sided interviews. Are they still conducting interviews? I want to know that. The thing that you're asking for, is it even finished? Meanwhile, the investigation has dragged on for nearly 5 months, conveniently providing a pretextual basis for Wayfair to refuse to produce otherwise patently discoverable information. So, yeah, it's just not done. Do you not want them to be thorough when investigating supposed sexual harassment in the workplace? Miss Blake Lively, who, supposedly champions safety for women and girls? Do you not want that? Particularly given Wayfair's publicly stated foregone conclusion that Ms. Lively's allegations are not true, Wayfair is not permitted to wield the attorney-client privilege as a sword and shield, invoking the privilege for now, but insisting that it may waive it later at some unknown future date, presumably if and only if the investigation yields a result Wayfair likes, which it will no doubt publicly release with much fanfare. That is a lot of speculation. I feel like this is like a pre-defense. This is ridiculous. The motive is clear. Wayfair hopes to conduct shadow fact discovery. Will you stop with the shadow ninja bullshit? I mean, this is just ridiculous. Wayfair hopes... It's pretty common for these kinds of things to take place behind closed doors. You don't just like air this out in the public while it's happening. Wayfair hopes to conduct shadow fact discovery under the pretext of an attorney investigation to prevent Ms. Lively from obtaining critical information until it is too late. Wayfair's refusal to confirm its position on the attorney-client privilege is improper. Moreover, regardless of whether Wayfair intends to rely on the investigation at trial, its choice to initiate the investigation in the middle of contentious litigation years after the events at issue first arose means that it must disclose the underlying materials now during discovery. Okay. Let me see what this footnote says. During the parties' conferral, Wayfarer's counsel, Brian Friedman, incorrectly asserted that its obligation to investigate or take corrective action was mooted by the parties' execution of the Return to Production Protections document in January 2024. Setting aside the legal fallacy, Mr. Friedman's position is a death knell for any argument that is a legitimate, neutral workplace investigation consistent with Wayfair's legal obligations. According to Mr. Friedman, there is no such obligation. So they're complaining that they started this in January 2025, but she made her complaints in December 2024, right? And so like she never made any actual formal complaints of sexual harassment or otherwise. They signed this document, the return to production demands or whatever, but they were not admitting that that happened, and it wasn't a formal complaint to, Sony or anything like that. So I don't understand, like, why is that? If all of a sudden you're in the press making serious sexual harassment allegations, then yeah, maybe open up an investigation. I mean, what? Okay. Shadow ninja bullshit. Yeah. No, man, I'm so tired of them saying shadow campaign. Not everything's a shadow campaign. Some things are just private. And also, people just don't like you. So, all right. Wayfair's refusal to confirm its position on the attorney-client privilege is improper. Okay, we went through that. Since late January, the investigators have contacted potential witnesses and, in doing so, represented that they are conducting a neutral fact-finding investigation. Upon discovering this, Ms. Lively immediately raised concerns directly to the investigators and to Wayfair about the investigation proceeding in parallel with discovery of this action, its purported neutrality given Wayfair's publicly stated position, and the risk of confusing or tainting witnesses, among other issues. In March, given these concerns, Ms. Lively requested that, to ensure transparency, The investigators make several disclosures to witnesses, including disclosing at the outset that they were retained by Wayfarer, which alone would control the investigation materials. Both Wayfarer and its investigators have refused to share any details about the investigation that's ongoing and does not yet have a conclusion. For example, who has been contacted, what topics have been discussed, and when the investigation will conclude. They have also refused to confirm what disclosures are being provided to witnesses or to share with Ms. Lively any materials created or obtained, including their audio recordings of witness interviews. On March 31st, Ms. Lively served the requests, seeking 1, all documents and communications concerning the investigation, 2, all notes, recordings, and interview memoranda, 3, documents identifying each person contacted or interviewed, and 4, all communications between the investigators and any person concerning the investigation. One sec. Somebody says this is normal to keep confidentiality and prevent retaliation. I mean, I would agree with that. I don't know how that goes with like an ongoing lawsuit and discovery and stuff, but to me, it sounds like this is something that should, they should be able to keep private for now. Lauren, do a pro bono psych eval on this deranged person. Okay, well, my conclusion is that this has nothing to do with mental illness. This person is just an asshole. So, I mean, whatever. That's how I feel about, honestly, most people who are doing shit like this. Not like patients, you know what I mean? But like most people who are playing shit out like this in the press. All right. Okay. On April 30th, Wayfarer responded with boilerplate objections invoking attorney-client privilege and work product protection. While initially claiming they would produce relevant non-privileged documents within their possession, custody, or control, during the parties' conferral, Wayfarer's counsel represented that they did not have the investigation materials. When asked whether Wayfarer intends to assert the attorney-client privilege, counsel responded that they assume so, but we're not sure if Wayfarer would rely on the investigation materials at trial, since the investigation is ongoing. Okay. Meanwhile, the investigators have refused to produce anything in response to subpoenas issued to them, absent a privilege waiver from Wayfarer or a court order. They have also failed to provide a corresponding privilege log, or to even confirm that they would do so. The investigation materials are highly relevant, are necessary for Ms. Lively and the court to ensure that witness engagement has been proper, and have been put at issue by Wayfarer. They must be produced. First, Wayfarer is not permitted to assert blanket objections and categorically withhold documents on attorney-client privilege or work product grounds without identifying the specific materials being withheld and establishing a factual basis for the asserted protection. Here in 2, it says Ms. Lively certifies that the parties conferred on the issues raised in this letter. To date, defendants have not produced any documents in this case, while Ms. Lively has produced thousands of pages. But we know from last week that she had not yet produced any pages. So she must have just dumped that on them today. I'm so impressed. All right. Wayfarer's other objections, including burden and privacy, similarly fail. Their vague references to third-party privacy or reputational concerns do not justify withholding responsive materials, particularly where a protective order is in place. Finally, Wayfarer appears to be withholding documents based on an investigator's privilege, which does not exist. Okay. Second, Wayfarer has not come close to meeting its burden to show that the attorney-client privilege or work product protection applies to the investigation materials. Wayfarer has failed to explain why or how witness interview notes, interview recordings, or communications with third-party witnesses are privileged, and it is not even confirmed that the investigators are rendering legal advice rather than simply conducting a neutral fact-finding investigation, as they have repeatedly suggested. Wayfarer cannot manufacture protection by rerouting an otherwise discoverable factual inquiry through attorneys. Third, Wayfarer waived any applicable attorney-client privilege or work product protection by, among other things, placing the adequacy of the investigation at issue vis-a-vis its 13th affirmative defense, that it appropriately, completely, and fully performed and discharged its legal obligations. Okay. The adequacy of Wayfair's response to Ms. Lively's workplace sexual harassment complaint is a central issue in this case and is the entire basis of her sixth cause of action. And the investigation materials are unquestionably within Wayfair's possession, custody, or control. Wayfair hired the investigators, and its relationship with them gives Wayfair the legal right to access the investigation file. Finally, allowing Wayfair to withhold the materials on the basis that the investigation is ongoing or privileged, while reserving the right to produce later, if deemed favorable, is highly prejudicial to Ms. Lively given the posture of this case. Reserving the right to produce later if deemed favorable. Those are your words, yes? It deprives her of the ability to test the scope, credibility, or timing of the investigation, much less obtain the fact witness information the investigators have been collecting over the last 5 months, which Wayfarer may use now. I haven't seen anybody use it now. Wayfarer should not be allowed to conceal critical evidence during discovery, only to weaponize it later at trial. Okay. Fact discovery closes August 14th, with substantial completion of document productions due by July 1st, and as such, the time for Wayfarer to produce documents is now. I mean, it's still May, but all right. For the foregoing reasons, Ms. Lively respectfully requests that the court compel Wayfarer to produce all responsive documents immediately, including all witness recordings. All right. This was a letter on February 14th. Well, that's redacted. I don't know. On behalf of our client, Blake Lively, I write to respond to your letter of January 31st and to follow up on our conversation of February 12th. In your letter, you state that Wayfair Studios has retained your firm. Okay, so it's to the, okay, I got it. To conduct a neutral third-party investigation of Blake Lively's complaint for sexual harassment, retaliation, failure to investigate, prevent, and/or remedy harassment, and aiding and abetting harassment. You asked to interview Ms. Lively to fulfill Wayfair's legal mandate to investigate. With respect, we find this years too late request baffling and must decline it. So she doesn't want to participate. All right. As you note in your letter and confirmed on our call, employers have a legal mandate to investigate complaints of harassment. A failure to investigate is itself unlawful. Okay, but somebody has to make a complaint of harassment, right? That didn't have it. Sitting somebody down in your penthouse and being like, sign this or else, I don't know if that really qualifies. You guys tell me. However, the law mandates not just any investigation, but one that is prompt, thorough, and effective. Wayfair's proposed investigation is clearly none of those. First, the fact that your firm has only been retained now, nearly 2 years after Ms. Lively first raised her harassment complaints in May 2023, makes a mockery of the law's requirement of a prompt investigation. As the EEOC has noted, even a 2-month delay in investigating fails to meet the statutory requirement of a prompt investigation. When we spoke, you had no explanation for Wayfair's nearly 2-year delay, and indeed you stated that this delay was one of the issues you were going to investigate. The fact that Wayfair has only now decided to investigate Ms. Lively's claims irrefutably proves it has violated its obligations under California, federal, and other applicable law to take prompt action when presented with a harassment complaint. He says those same harassment complaints Sony knows absolutely nothing about, correct. So they had this weird closed door meeting where they berated people, forced them to sign a document or they wouldn't participate in completing or marketing the film, and then are later being like, well, we raised a sexual harassment complaint. That's not what that means. Am I crazy? Don't answer that. That has nothing to do with what I'm talking about here. Never mind. Okay. Second, an investigation must be thorough. All right, we do this. As you know, the misconduct Wayfair now claims it wants to investigate is the subject of multiple federal lawsuits involving multiple parties and dozens of witnesses nationwide, very few of whom are current Wayfair employees. Any thorough investigation must entail speaking to all of these witnesses and reviewing any relevant documents and information they possess. However, when we spoke, you acknowledged you have no authority to compel anyone to speak to you, and that you would be relying on Wayfair, led by the very people who are the accused parties, to provide you documents and to set the scope and budget of the investigation. Further, Ms. Lively alleged that the retaliation campaign perpetrated by Wayfair and others against her was designed to be shadow ninja shit. But you could not explain how you would be able to investigate these allegations given the limits placed on your authority, including a lack of subpoena or other discovery power. Needless to say, an investigation that relies on the accused to set its scope and budget and provide self-serving documents and witnesses is not one designed to get to the truth. I can see why that would be concerning. Yeah, if this were an actual case of somebody who was sexually harassed, absolutely. That's just not what's going on here. Third, an investigation must be effective, designed to lead remedial action to stop the harassment. You told me your role would be one of fact gathering and that you are not charged by Wayfair to make any recommendations or suggest corrective action. As a matter of law, this is not an effective investigation. On our call, you acknowledged that if these incidents occurred, as alleged, there are significant problems within the organization that they will have to contend with. We, of course, agree, but rather than recommend remedial action, you told me that any report you might issue at the conclusion of your investigation, which could be oral or written at Wayfair's discretion, would leave it up to Wayfair or its lawyers to decide what to do. Further, you told me that it would be up to Wayfair whether to release any report or to bury it under a claim of attorney-client privilege. Look, again, my issue here is not whether or not, like, under normal circumstances where something was actually, like, something actually happened and was properly reported, I could understand all of this. But again, that's not what happened. Wayfair and its counsel have spent the past few months in the press calling Ms. Lively a liar, stating there was never any retaliation, and claiming that she invented her claims of sexual harassment out of malicious intent to harm them. Okay. Indeed, just a few weeks before you sent your letter, Wayfair and its principals filed a 9-figure lawsuit against Ms. Lively and her husband, asserting that the very claims Wayfair now would have you investigate are false, defamatory, or even extortionate. Moreover, from the moment they understood that Ms. Lively complained, Ms. Lively has alleged that Wayfair and its principals have been on a stated mission to bury and destroy her and those who defended her. Against this backdrop, it is clear that Wayfair's belated investigation is a sham designed not to get at the truth, but to obscure it. Perhaps if Wayfair had complied with the law and retained your firm to investigate Ms. Lively's claims when she first raised them in May 2023, she would have agreed to participate and the parties would not be in litigation today. Unfortunately, Wayfair ignored its obligation and has repeatedly doubled, tripled, and quadrupled down on its conduct. Accordingly, Ms. Lively declines your firm's request for an interview, and she will instead continue to rely on the legal process to resolve her claims. Yeah, okay, so she won't participate in this investigation. They're complaining that Wayfair has total control over who is interviewed and what they're asked and all that. And then she's like, yeah, but I'm not going to participate. I'm not going to participate in that. So, you know, that's fine. Again, there's making a sexual harassment complaint, and then there's ambushing someone in your home with a document that says you cannot do this, this, or this, forcing them to sign it or else, and then going on to do whatever the fuck they did for the last 2 years. That's not making a sexual harassment complaint. So that in itself to me is why this is all bullshit. So if there was an actual complaint made and they can produce that, then yeah, I would concede that. This would have been a terrible way to handle this. All right. On the issue of Wayfair's counsel, you stated that any represented party would be permitted to have counsel present during their interviews with you. We note that all the material Wayfair party witnesses are represented by Brian Friedman, who has repeatedly publicly attacked Ms. Lively as a liar, including but not limited to calling her heinously selfish, heinously selfish, and has scoffed at her sexual harassment claims, saying they exploit actual victims of real harassment and are completely false, outrageous, and intentionally salacious. And actual victims of real harassment are largely in agreement. Not everybody, right? But a lot of them. No interview in which Mr. Friedman is present could be neutral. I mean, I could see that, honestly. So this was a few days later, and the firm's writing back. Dear Ms. Hudson, we received your letter declining Ms. Lively's participation in the investigation of her claims. While we acknowledge and respect your concerns, certain aspects of your letter mischaracterize our role, statements, and the fundamental nature of workplace investigations. Timeliness, let's see. Wayfarer retained our firm to investigate the claims made in Ms. Lively's recent legal filings before the CCRD and the U.S. District Court, Southern District of New York. Your client contends that the allegations surfaced years ago and should have been investigated. The scope of our investigation includes whether Ms. Lively filed complaints. Okay, so yeah, there we go. Whether Ms. Lively filed complaints and whether Wayfarer failed to investigate them. We will determine through this investigation whether a preponderance of the evidence supports her claim. Even if Wayfarer failed to investigate Ms. Lively's prior complaints as she alleged, Wayfarer still must investigate subsequently filed complaints. Regardless of timing, once serious allegations come to light, a neutral investigation remains a necessary and appropriate step, and we intend to carry out that obligation in accordance with best practices. Scope and independence. Let's see. You expressed concerns regarding the scope of the investigation, Wayfarer's payment of our fees, and the absence of subpoena power. While Wayfarer retained us, the core function of an independent workplace investigation is neutrality. Wayfarer does not dictate our investigation, nor determine whom we interview. Well, that was kind of an important thing to get right. We pursue all relevant facts, including information from witnesses identified by any involved party. Your assertion that Wayfarer will determine who we interview mischaracterizes our process. As neutral third-party investigators, we rely on voluntary witness participation. This limitation is not unique to this situation, nor reflects a deficiency in the investigative process. It is simply how investigations function in the employment context. Unlike litigation, workplace investigations do not afford subpoena power or other coercive measures to compel testimony. Instead, the process is designed to obtain information from those willing to come forward. Sorry, there's a bug. Current company employees are typically required to cooperate per company policy, but external witnesses, such as former employees or third parties, may choose whether to participate. We make diligent efforts to identify and interview relevant witnesses, follow up with those who may initially be reluctant, and document any individuals who decline to participate. If a witness refuses to engage, that does not mean the investigation is ineffective. Rather, it is a reality inherent in this fact-finding process. To suggest otherwise would be to hold us to an impossible standard that is not aligned with how neutral workplace investigations operate. Your letter appears to frame these procedural realities as flaws, but in doing so, it creates a paradox. You acknowledge our role as independent investigators, yet simultaneously critique us for not having powers that no independent workplace investigator possesses. It is important to recognize that our role is not to compel participation, but to pursue the facts as thoroughly as possible within the framework of an impartial workplace investigation. We welcome information from all sources, including your clients, and encourage the identification of any relevant documents or witnesses who may contribute to a complete and accurate assessment of the facts. Despite your client's decision not to participate, we remain open to receiving any information, documents, or witness names that your client believes would be relevant. Our objective remains to determine the facts as comprehensively as possible, regardless of whether Ms. Lively actively participates in the investigation with a witness interview. Neutrality of interviews with counsel present. Let's see. You have also raised concerns that an interview conducted in the presence of company counsel can never be truly neutral. As we discussed during our call, while counsel is always permitted to be present, particularly when legally required in the case of represented parties, their role is strictly observational, not participatory. If counsel, whether for Wayfarer, Ms. Lively, or any other third-party witness, oversteps that boundary and attempts to interfere with the neutrality of the interview process, we document that in our report and take appropriate corrective measures to ensure that such conduct does not interfere with the integrity of the investigation. Our role as investigators remains independent, and we do not permit counsel's presence to compromise the fairness of our findings. Okay. Your letter also raises concerns about our ability to investigate alleged practices that may have been designed to be untraceable. As we explained, we understand the nature of the allegations and will take appropriate measures, including working with third-party professionals where necessary. The expectation that we should, at the outset, outline all specific investigative methods we will employ is unrealistic. The nature of workplace investigations requires adaptability as methods evolve based on facts uncovered during the process. You state that our investigation cannot be effective because we do not issue recommendations. This reflects a misunderstanding of our role. We aim to determine facts and identify concerns, not implement workplace changes or dictate corrective actions. What the company ultimately does with our findings is beyond our scope, but identifying and documenting issues is the first step in addressing workplace concerns. Holding us responsible for implementing changes would fundamentally alter the role of a neutral fact finder. One sec. To state the obvious, if our investigation results in documented findings of harassment or other improper workplace conduct, and the employer fails to take appropriate remedial measures, they will undoubtedly face the consequences both legally and reputationally. This is particularly true in this case, where any actions taken will be subject to heightened scrutiny. The employer ignores substantiated findings at its own risk, as failing to act on investigative conclusions could lead to liability, regulatory scrutiny, and significant reputational harm. Whoa, sorry about that. That reality underscores why independent investigations are critical to responsible workplace management. Wayfair's decision on whether and how to act on our findings is separate from our function as investigators. However, the notion that our work is ineffective simply because we do not dictate the next steps mischaracterizes the purpose of an independent investigation. Our findings serve as a foundation for informed decision making, and any suggestion that they can be disregarded without consequence is unrealistic. We acknowledge your concerns regarding the privileged nature of our investigation and Wayfair's ability to assert or waive privilege. However, as I trust you are aware, it is standard practice in workplace investigations that the privilege remains with the employer. This does not mean we are beholden to the company. As we discussed, our communications with the company and its representatives during the investigation are limited to logistical matters and status updates, not the specific substance of witness interviews. As we assured you on our call, it is not our practice to share investigation notes or findings with our clients before the completion of the report. Dude, then what the fuck is this? This whole motion is stupid. We understand the skepticism surrounding our role, particularly given the public nature of these matters and the adversarial nature of litigation. However, our obligation remains to conduct a thorough, impartial investigation consistent with professional best practices. Ms. Adam and I have conducted hundreds of workplace investigations within these standards, and we take our role and responsibility very seriously. While we respect your client's decision, we urge reconsideration. Participation in this process allows for a full and fair assessment of the claims. As noted, regardless of whether Ms. Lively chooses to be interviewed, we remain open to receiving any information, witness names, or documents your client believes should be considered in determining the truth of the allegations. So they're saying Wayfair has full control over who is interviewed and all that. But she declines to participate, and then also they know, like, very well, based on what we're reading here, that they can give them witness names or people that they need to talk to. So, like, what are you doing? Okay, so this is like over a month later. Cease and desist demand. This is from Blake's attorneys back to the firm. Based on our prior correspondences and teleconferences, we understand that you have been retained by Wayfair and have been instructed to conduct an investigation into Ms. Lively's claims regarding a hostile and harassing work environment on the set of It Ends With Us, and the subsequent retaliation against Ms. Lively for taking steps to protect her and others on the set. God, you're such a hero. Issues that are subject to active litigation and ongoing discovery. We have recently learned that, notwithstanding our February 14th correspondence outlining the numerous ways your so-called investigation is improper. God, what a dick. You've been contacting witnesses identified on the parties' confidential initial disclosures, representing yourselves as third-party neutral investigators. As described below, these efforts are misleading. They threaten to taint witness evidence in the case, and they must stop immediately. Okay. First, in your introductory correspondence to these individuals, all of whom are witnesses in an active litigation matter, some of whom are represented by counsel, you fail to disclose that your supposedly neutral investigation is bought and paid for by Wayfair. Even worse, you failed to disclose in that correspondence that you are acting as Wayfair's lawyers, and as such, Wayfair will be the sole party that has access to the information that witnesses may be providing. You have informed us that you are taking the position that this investigation is confidential and privileged, which means that although Wayfair will have access to your investigation notes, documents, records, and audio recordings of witness interviews, neither Ms. Lively nor third-party witnesses with whom you will meet will have such access unless Wayfair chooses to waive the privilege. Your introductory correspondence fails to disclose this and instead goes to great lengths to misleadingly portray your own investigation as independent and neutral. Okay. Based on your correspondence, potential witnesses will surely not understand that they are being interviewed by Wayfair's lawyers, who are investigating at Wayfair's instruction and providing work product directly to Wayfair to use in whatever way Wayfair sees fit, including potentially using that information against such witnesses in the ongoing litigation where, unlike in your investigation, they will be testifying under oath. It is plain to see how witnesses may be confused about who you are, what will happen to the information you collect, and how it may be used against them. They may wrongly believe that your investigation is part of the litigation discovery process in connection with the actions in which they are legally required to participate, or that you have been tasked to investigate by the court or mutually by the parties on both sides of the litigation. I don't know. I feel like they probably make that pretty clear. Your introductory correspondence fails to anticipate or prevent any of these misunderstandings, further failing to clearly and unambiguously disclose that you have been retained and are working for Wayfair may violate your ethical obligations under both California and New York law. I feel like this is, I don't know. I don't know about this, man. To be sure, a lawyer is required to be truthful when dealing with others on a client's behalf. I feel like this is a pretty big accusation to make, though. These laws make clear a non-disclosure can be the equivalent of a false statement of material fact or law under paragraph A, where a lawyer makes a partially true but misleading material statement or material omission. But where did anybody do that? Is what I'm asking. Are we just assuming? Critically, in communicating on behalf of a client with a person who is not represented by counsel, a lawyer shall not state or imply that the lawyer is disinterested. Okay. Are you going to show me what you're talking about, though? Whereas here, a lawyer knows, or reasonably should know, that the unrepresented person incorrectly believes the lawyer is disinterested in the matter, the lawyer shall make reasonable efforts to correct the misunderstanding. Okay. But where was there an incorrect representation of that? Your statements to these unrepresented third-party witnesses are at best highly misleading, particularly given your effort to distance yourself as attorneys that have been retained by Wayfair and may violate your ethical obligations as attorneys. The bottom line is that no investigators who are retained, paid, and instructed to investigate by Wayfair under the current circumstances of this matter can reasonably assert that they are neutral. Second, your primary source of information for the scope and basis other than publicly filed documents is Wayfair itself. Thus, the lines of questioning that you may direct to witnesses sourced from information Wayfair provides to you may be designed to improperly influence their recollections, plant ideas or themes in their mind, may be designed to improperly influence their I just read that. Wow. Their future testimony under oath in the litigation process. No matter how much you may believe that you are acting professionally and in good faith in this investigation, you must recognize how fraught and dubious this process is, given the timing of this investigation nearly 2 years after the events at issue, when the film production has long since ended, the ongoing litigation, and the extraordinary and aggressive actions your client Wayfair has taken to date. But again, they said whether or not she made complaints is part of this investigation, because there were no complaints made. By instituting this private investigation under the guise of neutrality, Wayfair appears to be attempting to ascertain how witnesses will testify in a closed environment and without affording Ms. Lively or anyone else the opportunity to examine those witnesses. Such abuse of process not only interferes with ongoing discovery in the actions, but also threatens to intimidate and confuse witnesses. Third, it is particularly egregious that the investigation is portrayed as neutral and independent, given the public statements of the client on whose behalf you are working. Specifically, Wayfair has already committed itself to the legal position that Ms. Lively's allegations of harassment and retaliation are entirely false, that Wayfair was under no obligation to investigate anything, that Ms. Lively is a liar, and that she has defamed them to the tune of hundreds of millions of dollars by even making such allegations. What, then, is the possible purpose of your investigation other than to unduly influence witnesses and end run the discovery process? I don't have an answer for that. I mean, again, I kind of get it. Kind of. For example, no one could possibly believe that Wayfair would voluntarily disclose a finding that Ms. Lively's allegations are substantiated, given that doing so would require Wayfair not only to dismiss its nearly $1 billion of litigations, well, 400 million isn't even half of a billion, but go on, litigations against Ms. Lively, but also be subject to fee shifting, treble, and punitive damages for bringing meritless claims against her. Instead, the apparent purpose of this exercise is for Wayfair to bury any unhelpful findings under the attorney-client privilege, publicly release any findings Wayfair deems useful, and perhaps most importantly, use any and all information you obtain from witnesses to its advantage as much as possible in the litigation. Blake hates an investigation. She told everyone not to investigate everything she said, including the CCRD. Yeah, I guess. All right. As a reminder to you, the client for which you are purporting to conduct this neutral investigation has, in the last week and through its counsel, told the entire world in a statement to the media that Wayfair and its leadership are innocent, and that Ms. Lively's claims of harassment and retaliation are an abuse of the legal system, pure malice, false, and fantastical. This statement is part of a long list of defamatory statements made against Ms. Lively that have resulted in your client being sued for defamation. Moreover, keep in mind that your client is suing Ms. Lively into oblivion and maligning her reputation at every opportunity, despite the following facts. Wayfair has already admitted that Ms. Lively raised concerns during the production to Justin Baldoni, Jamie Heath, and others, which were contemporaneously documented. Mr. Baldoni even issued a written apology to Ms. Lively and another female cast member. I don't know about a written apology. I haven't seen anything about a written apology. I know they signed those return to production demands. That was not a sexual harassment complaint. So. Mr. Baldoni, who was the director and executive producer of the movie, as well as the co-founder and co-chairman of the studio that owned the movie, was Ms. Lively's boss at every turn. Notwithstanding that role of authority, Ms. Lively's lawsuit alleges that Mr. Baldoni spoke about his pornography addiction, divulged information about his sex life, made derogatory, degrading, and sexual comments, described his own genitalia, improvised intimacy that had not been rehearsed, choreographed, or discussed with Ms. Lively in advance, added graphic content to the script, including a birthing scene for which he cast his friend as her OBGYN. We're really still going with that. Jesus. This is not even the full list of his misconduct alleged in Ms. Lively's complaints. Ms. Lively was not the only one who was uncomfortable with Mr. Baldoni, as she set forth in her lawsuit, supported by documentary evidence. What evidence? What evidence that you were not the only one who was uncomfortable? Mr. Baldoni and the Wayfair parties have already admitted that they created a media and social media plan in case Ms. Lively made her grievances public, in which they planned to plant stories suggesting Ms. Lively was a bully and weaponizing feminism. First of all, where's the lie? They have admitted that they were able to bury anyone. They have admitted that they bragged and laughed at how negatively the narrative had shifted against Ms. Lively at the same time this plan was hatched, and how successful they were at confusing people. We're really mischaracterizing a lot of this. They've admitted that they said they started to see a shift on social, due largely to Jed and his team's efforts to shift the narrative. Their text and email communications are in Ms. Lively's lawsuit, and even their own to a large extent. Right, in their own, because they don't mean what you're saying they mean. There is zero basis to believe that your client has any sincere interest in a neutral investigation into its conduct, given it has gone on brutal offense against her despite these facts and allegations. If it had any such interest, perhaps you can explain why Wayfair did not initiate such an investigation until after it had been sued for sexual harassment and retaliation, more than a year after it confirmed in writing that it had been notified of the underlying sexual harassment allegations. Again, that return to production document is not a sexual harassment complaint. This investigation appears to be an attempt to circumvent the discovery rules prescribed by the Federal Rules of Civil Procedure, and you should not allow your firms to be a tool in doing so. We hereby demand that you immediately cease and desist from further pursuing this sham investigation. You want to talk about a sham investigation? Okay. And from contacting any additional witnesses as part thereof. We further demand that you immediately, 1, identify each and every person that you have contacted to date, 2, disclose all written communications with each such person, and 3, produce all documents, including interview notes and audio recordings related to the investigation and communications with any person regarding the investigation. The documents and information are required to be produced because Wayfair has put your investigation and its legitimacy directly at issue by maintaining that it has appropriately, completely, and fully performed and discharged any alleged obligations and any alleged legal duties arising out of Ms. Lively's allegations. We hereby demand that you respond to this letter confirming in writing that you will cease any further activity related to the investigation by no later than 9 PST on Monday, March 31st. Even if you disagree with the assertions, you must confirm at that time that you will immediately cease contacting any further witnesses in connection with the investigation until we have an opportunity to raise this issue with the court. If you fail to do so, we will promptly raise the foregoing with the court and seek all available sanctions against the Wayfair parties and reserve all rights and remedies against you and your respective firms. Okay. We already saw this one. I'm not sure why they're putting this in here again. This was the first one we read, I think. Yeah. April 8th. Okay. Dear Ms. Hudson, we've now had a chance to review your letter dated March 28th. In it, you demanded we immediately cease our independent investigation of Blake Lively's complaint against Wayfair Studios, LLC. One second. You further demanded that we identify every individual contacted and turn over all notes, communications, and recordings related to those interviews under threat of court intervention and sanctions. That demand is baseless, procedurally improper, and substantively indefensible. As experienced employment counsel, you are undoubtedly aware that the approach we have taken reflects not only legal compliance, but standard workplace investigation practices. Your letter reflects a willful mischaracterization of our role and the protections afforded to such investigations. Your letter appears designed to obstruct a lawful process and chill the participation of witnesses who might otherwise assist in a fair, impartial, fact-finding endeavor. To reiterate what we told you on our February 12th call and again in our February 17th correspondence, we are not litigation counsel to Wayfair and do not operate under any litigation or public relations strategy. This is not an adversarial role, and we conduct our work free from external pressures, including those arising from pending litigation. Your assertion that we are conducting an illegitimate investigation or that we have been bought and paid for is disingenuous. The investigation is timely. As soon as Wayfair learned of Ms. Lively's December 2024 complaint to the CCRD, Wayfair immediately took steps to retain our respective firms to initiate and conduct a neutral workplace investigation to investigate any unresolved claims. As you are well aware, Wayfair has the absolute right to conduct this type of workplace investigation. Your claim that our investigation is a sham designed to interfere with litigation is equally baseless. If taken seriously, your position would effectively nullify the entire purpose of workplace investigations. To suggest that an employer loses its right and ability to investigate claims of misconduct merely because a lawsuit has been filed is unsupported by any legal authority. To the contrary, courts have repeatedly affirmed that the pendency of litigation does not extinguish an employer's duty to investigate, nor does it negate the employer's right to gather relevant facts from willing witnesses, provided those efforts comply with applicable ethical and legal standards. Your allegation that we have misrepresented ourselves to witnesses is not only factually incorrect, it is reckless. In every instance, we have clearly identified ourselves as neutral investigators, disclosed our retention by Wayfarer, and emphasized that participation is entirely voluntary. This is what I'm talking about. Like, why were they suggesting otherwise? Did something actually happen to get you to suggest otherwise, or were you just guessing? For any witnesses we believe may be represented, we explicitly request counsel's contact information and confirm that their attorney is welcome to attend the interview. These outreach practices fully comply with Rule 4.3 of both the California and New York Rules of Professional Conduct. Your accusations to the contrary lack any evidentiary support and appear aimed solely at undermining the credibility of fellow members of the bar without cause or justification. Your claims regarding privilege are similarly misplaced. Independent workplace investigations conducted by outside counsel are routinely protected by attorney-client privilege and the attorney work product doctrine. As the courts have repeatedly upheld, this confidentiality is not a flaw but a feature. It ensures that employees and investigators can gather facts candidly, confidentially, and fully. The public nature of this litigation only reinforces the importance of preserving confidentiality throughout the investigative process. Public scrutiny of an ongoing investigation can compromise witness candor, distort facts, and undermine the very neutrality that we are bound to uphold. While Wayfair may waive privilege after the investigation concludes, that is their decision. Until then, no legal authority compels the premature disclosure of privilege or protected work product. Even if Wayfair were to waive attorney-client privilege, that would not and could not compel the production of attorney work product, which the investigating attorneys hold. The notion that witness interviews may only occur through adversarial depositions is not supported by law. Courts have repeatedly recognized the right of parties, including non-litigators such as workplace investigators, to conduct interviews with witnesses outside of formal discovery. Investigators are not precluded from speaking to individuals with relevant information, and those individuals remain free to decline. We see no lawful basis for ceasing an investigation authorized by federal and state law, and we have no intention of doing so absent a court order. We will continue to conduct ourselves in accordance with standard practices and our legal and ethical obligations as court officers. Moreover, we hereby demand that you discontinue making false and meritless assertions and reserve all rights, remedies, and privileges. Your cease and desist letter constitutes unlawful interference with an ongoing investigation and is plainly meant to try to intimidate participants and obstruct the process. Finally, we understand that you have asked us to accept service of subpoenas directed to members of the investigative team. We do not believe these subpoenas are appropriate or enforceable given the legal protections discussed above, but in any event, we will not be accepting service. We remain committed to conducting this investigation with the independence, professionalism, and integrity that it requires and the law demands. The last two are filed under seal. Dude, I'm losing my voice. The last two are filed under seal, so we can't see that right now. Maybe later, but we'll see. All right, so she's really trying to stop this investigation into her claims, which is interesting. And then they're accusing them of doing all kinds of shit that there's like no real proof of them doing anything like that. Like saying like they didn't tell them they were retained by Wayfarer when I don't see any actual evidence of that happening or any concrete examples of that happening. It's just, well, you could have done this, but they didn't. They didn't do that. You could have filed a formal sexual harassment complaint, but you didn't. Okay, let me get through these and I gotta go to work. Ali C, thank you for the 10. I appreciate you. Moonlight Receipts, thank you for the 14. Thank you for keeping up with her Looney Tunes filings the moment they hit the Space Jam docket. That is one way to put it. Because at this point, even Bugs Bunny would be like, what's up with the docket? Oh, I get it. I get it. Thank you, dude. I appreciate you. Sherry White, thank you for the 10. Thank you, Lauren, to help with cost obtaining new filings. That's always appreciated. Thank you very much. Redondo Beach, thank you for the 2. The hardest working woman on YouTube. I mean, I'm certainly trying to be. All right, thanks, guys. I got to get back to my work desk now. So actually, please, nothing else happen for at least a few more hours. That would be fantastic. All right, bye.